All right, we are ready to start the August 7th, 20th public meeting of the Mass Gaming Commission. I will call a meeting to order, and we will start out by approval of minutes for the two meetings on July 17 and one meeting on July 26th. Are there any comments or questions about the drafts? Any issues, Commissioner McHugh?
I have no issues.
Okay.
Mr. Chairman.
Can we adopt them all at one time?
We can.
All right.
And I would move that if there are no corrections to the meetings, that the minutes of the July 17 regular meeting, the July 17 special meeting, and the July 26 meeting be approved as included in the form in which they're presently before the Commission.
Second. Any discussion? All in favor? Aye.
Aye.
All opposed? Okay. We are going to skip straight to item 5 on the agenda. The most important thing we have to do today is hope we will finalize our discussion of the first voluminous set of regulations that will oversee the request for applications part 1. That's a momentous step, and we want to make sure we get it done, so we're going to do that first with the help of our consultant teams. Commissioner McHugh, do you want to orchestrate this?
I would, Mr. Chairman, thank you very much. And by way of prologue, let me say that the regulations that have been drafted by a team that I'll mention in a second are before the Commission now. They deal with 3 aspects of the Commission's business. First of all, hearings and practice before the Commission, some access to records and confidentiality of records, the Investigation and Enforcement Bureau. Those are the structural aspects that the regulations deal with. They also deal with external regulation in the sense of political contributions and financial aid to cities and towns. And most importantly, for present purposes, they deal with the Phase 1 application process. Later regulations will deal with Phase 2 and with the standing rules that will govern the operation of the casinos. The regulations that we have today to consider are the product of an effort by a terrific team consisting of Guy Michael and Bob Carroll, who are here, Steve Ingus from Spectrum, and Fred Gushin, who's not with us today, Steve Anderson and Bill Leahy, Kathy O'Toole, and Kristen Gooch. That whole team has come together really to work together as a team to create these regulations, and we've had the benefit of input and help and a quick review, but thorough review and thoughtful review by representatives of the Attorney General's office. Before I turn it over to the consultants who I'd asked to give us a high-level view of some of the more salient sections, I think it's important for everyone to understand what it is that's happening today. We are going to have a discussion of the draft regulations. We're going to make revisions to those regulations based on the comments that emerge from today's meeting. And in addition to those, there is another draft that's already, preparation of which has already begun, that has done such things as put all of the contents of the regulations in a uniform style. Now some terms are capitalized and some aren't, and some phrases are different, although they refer to the same person. We refer to somebody as the deputy director in one place and the director in another place. All that needs to be cleaned up, and it's purely mechanical stuff. So that's going to be done. Then we will approve today the draft that we intend to set for public comment. This is really the beginning of a long process, not too long, a couple-week process of approval. We'll send a notice later this week that we intend to put these regulations out for public comment to the Secretary of State's office, and we will have them published by the Secretary of State so that the comment period can begin.
Begin August
beginning August 17. We'll submit them on August 17. They'll be published by the Secretary of State on August 31st, but they'll be up on our website in the interim. But the official publication date will be August 31st. And then in the second week of September, we'll have a public hearing on the comments that we've received and any other comments that people want to present at the public hearing. We'll gather together all the comments that we've received in the interim. And then after that public hearing, we will consider the comments that we've received, make the changes we think are appropriate, and submit the regulations to the Secretary of State again by the end of September, this time for publication of the final regulations. Those regulations will be published by the end of the second week of October, and then as soon as they are published, we can accept the RFA1 applications at our projected deadline of about October 15th. So we're on track to do that, and this is the process that we're going to follow to do it.
Am I right, Commissioner, that the process from the 17th until mid-October is a process prescribed by law?
Yes, I was just about to tell. No, I think that's an important point, Mr. Chairman, and I'm glad you raised it, because this is a process that's not one that's created by us. This is a process that the statutes and the rules promulgated by the Secretary of State require for all permanent regulations of the type that we're promulgating. It's done so that the public does have an opportunity to look at the regulations, to comment on the regulations, to participate in the process. It's perfectly consistent with our commitment to transparency, but it's independent of us. And so we, like every other organization in the Commonwealth that wishes to promulgate regulations, must follow this process, and it's a good one for those reasons.
Right. And just to emphasize, as a practical matter, the Commission this month starts our 5th month, and we will have, in 4.5 months, we will have, with the help of these folks, come up with about 80 pages of regs, which will govern, as you say, the first couple of critical parts of what we're doing.
Right. And so it is a significant milestone in our progress toward licensure. And I am now going to ask, if I might, our able consultants to give us some thematic highlights and overviews of the regulations. And then, of course, we'll open it up for discussion among the commissioners as to the specifics of the regulatory content.
Thank you, Commissioner, Chair, and members of the Commission. Guy Michael and Carol, as Commissioner McHugh has mentioned, Steve Ingus, Steve Anderson, and Bob Carroll here all have been busily at work on these regulations for some time. And in that regard, if I may start by congratulating the Commission on the alacrity and the diligence that you have all exhibited in putting these regulations together. This is not an easy process. This is created from clearly nothing. And what you have been able to do in the period of time that you've been able to do it is quite remarkable. It's, as the Chairman mentioned, approximately 80 pages. It's 17 chapters, and it covers a wide variety of material. It is not uncommon for a single regulation to take weeks, if not months, to create and evaluate and modify and put out for publication. This is 17 chapters of an entire segment of the operation of the Commission in terms of the substantive policy of the Phase 1 process and in terms of the overall administration and operation of the Commission itself. So from us to you, we congratulate you on your work. We can just generally review, and we'll take turns here, identifying some of the more important aspects, not important, but the more, I'd say at this point, the more substantive aspects of the regulations themselves. As I say, they govern 17 separate chapters, from the way the Commission operates to the standards for qualification and licensure, to the operation of the Commission's evaluation process and the IBA structure and so on. One of the key elements here, we thought, and you agreed, was how do we handle the confidentiality of information? And we have a a whole chapter dedicated to the manner in which the commission will receive information, identification of those aspects of the application that will be maintained as confidential, those aspects of the application that must, under Massachusetts law, be public. They are very minimal in terms of the entirety of the thoroughness of the application, the amounts that are public. But the commission has also put into place in these regulations a procedure by which applicants, if they choose to seek confidentiality of even those aspects of the application that might otherwise be public, can petition and have the commission determine to, in extraordinary cases, privatize those. What has been attempted here is a fair balance as between the need for confidentiality on behalf of the personal privacy of the applicant, balanced against the need for transparency for this process as the commission reviews this material. It should be emphasized, however, that, of course, the commission and its investigators will always have access to all of the information. We're only talking here about those aspects of the information that might be available for public consumption. In terms of the investigation itself, and it might be useful to just briefly identify the flow of how the application process would work. These are the Phase 1 application regulations, so they deal with how the Phase 1, the investigation, occurs. An application will be filed on a form that is delineated in these regulations. It will be referred to the IBE, or the Investigations Bureau. The Deputy Director of Investigations heads that bureau, referred out for investigation, and then a recommendation made after the completion of the investigation by the IBE to the Commission, and a Commission determination thereafter on suitability. The IBE is provided for here in terms of its function and its duties and its structure. It has authority to subpoena people. It has authority to require testimony under oath. There are regulations that govern the coordination of the IBE with the Massachusetts State Police, with the Massachusetts Attorney General, and even with the Massachusetts Alcoholic Beverage Control Commission. The goal is to enable the IBE to have access to as much information as possible, to conduct as thorough an investigation as possible, and provide the Commission with all the basis it needs for an informed and accurate decision. The IBE will also conduct hearings. However, the hearings themselves, what the IBE conducts, will not be in this Phase 1 process. They would be on licenses that are other than the casino license itself. The Commission conducts the hearings with regard to the casino license itself. I can go on if anybody else wants to jump in. I'll just one more section, on community and political contributions. This is one that is very sensitive, but at the same time very important. The regulations provide as the statute provides, for limitations on applicants' ability to make political contributions, and the regulations mirror the statute in that regard. But it's also felt that there should be an even further element of transparency with regard to both the political contributions that will be made by applicants and the contributions that the applicants will make to the communities themselves that would not be political, but for infrastructure and assistance and so on, that would be necessary for the communities to undertake this process. And so what the regulations provide here is for a mandatory disclosure in the application form of all such payments, contributions, and political contributions and community contributions, and that those disclosures would relate back to the effective date of the legislation. And there would be, it's a simple disclosure requirement, no penalties or anything incumbent on that, except for the fact that if in the course of the investigation it is determined that any contributions were made that were not disclosed, that would be a factor in evaluating the suitability of the applicant, and as would any information that was not disclosed, as it would be required to be disclosed in the application process. I don't want to take the whole thing.
Yeah.
I want to take...
I could mention briefly about the fees. We've also provided for a specification of the application fees as it relates to the process for the payment of those fees. We also have a provision in here regarding a process for the community disbursements. That will come into effect Obviously, when the application fee is received, and a portion of that will be earmarked and dedicated and held in escrow for the Commission's reimbursement of potential impact costs for local governments. The Commission has identified that as an area of desire to assist the local governments at the earliest possible stage within the confines of the statute and these regulations. It also provides for additional fees to be paid by applicants in regard to extra costs involving extensive investigations. It's clear that the typical background investigation and licensee application fee would not cover the whole cost that these investigations would entail, which run typically many, many months. With the idea towards efficiency and also for the cost to be borne by the applicant who is trying to get the license, those fees, those additional fees are in fact picked up by the applicant. And there's a process that confirms that that requirement is in place.
Bob, excuse me, we'll talk about this more, but I just want to mention that at our meeting in Western Mass, our educational forum in Western Mass tomorrow, we will be announcing that we're ready to receive applications, and the application form, we will release that form. So this is timely because it's going to start. The process really starts tomorrow.
In addition, we've also, again, confirmed and reiterated the statute's statement that the funds that are paid, the fees that are paid are in fact non-refundable. In addition to that, we've set forth the suitability determinations, the standards and procedures, which are set forth in the statute, but which have been codified here in the form of regulations as it relates to the specific standards that will be applicable for the Phase 1 licensee qualification and individual qualifier requirements and their compliance with those particular requirements that are set forth. It also requires and sets forth the proceedings that will be held before the Commission. We've also identified in subchapter 116 the persons who have to be licensed and who have to be qualified. This is an important segment because obviously it sets the framework for what the investigative responsibilities will be coming out of the Phase 1 application process. After the announcement of the Commission's opening, so to speak, to request the filing of applications, when those applications come in, the series of questions will always arise in every particular application as to, in our particular table of organization of our company, which people have to be qualified. That will engender a fair amount of exchange between the Commission and the applicants. We've set forth a framework for that to be done here. There's also a requirement for continued cooperation. That is, as these companies sometimes evolve due to their size, and in many cases their national, domestic and their international reach of their companies, that changes do occur in their management. There is a continuing duty on behalf of the applicants to make sure that the Commission information is updated and in fact is not left to an initial filing, but in fact is a process, it's an ongoing process of updating, and if there's any change in circumstances whatsoever involving a company's stature, that has to be provided to the Commission in a timely fashion. We've also provided for a determination initially of financial stability of certain qualifiers. That will be further refined going forward, but again, the purpose of the Phase 1 process as a whole is to determine the overall qualifications of these particular applicants so that you're assured going forward that before additional resources and so forth are dedicated, that in fact the applicants that are applying here meet the applicable statutory standards and the standards that have been amplified in these regulations.
The only thing I would add, it covered pretty much everything, is that we set forth the application requirements in terms of the various different application forms that would be required to be filed by a gaming applicant, the entities, and also the natural person qualifiers. The Commission will be using what is generally used throughout the United States, a multi-jurisdictional personal history disclosure form for the natural person qualifiers. In addition, there will be a Massachusetts supplement which will cover items that are not included in that form. And the entity applicants will be filing what's called a business entity disclosure form. The requirements for those forms are set forth in the regulations.
We're prepared to drill down on any of those or identify some of the, we thought those would be the most outstanding of the elements, just the nature of the structure of the agency and so on, where you file papers, all of that is covered in the regulations as well. But we're open to questions now rather than belabor those individual and very specific subjects.
Commissioner McHugh and consultant team, are there any issues, before we get around to our particular things, are there any issues which either in your mind still bear discussion or are sufficiently interesting enough policy questions that, that you want to talk about what has transpired?
There's only, we had a discussion about policy before and dealt with the major policy questions, Mr. Chairman. The only additional question that is perhaps worth talking about at a very high level for a minute is that this regulatory scheme, as we heard from our consultants, insofar as community fees are concerned, takes two approaches. Either the community and the developer agree on a fee to be paid out of the monies deposited with the commission for the application fee and supplements. That's one route. Or the developer and the community agree on a direct payment by the developer to the community to defray the costs of negotiation and investigation and the like, and then disclose what the payment is as part of the application so that everybody understands what has been, what monies have changed hands. That does not admit, at the moment, of any payments out of commission funds for those purposes. We had talked sort of generally at one point about whether commission funds would be available for that process. These regulations do not make any commission funds available for it. Now, that doesn't mean we can't change in the future. It just is something that's important for all of us to understand now about what these regulations do and don't do. And if that's not appropriate, not where we want to be, now's the time to discuss that insofar as phase one is concerned. That's the only sort of high-level issue I can see.
I have a couple of questions about that. One is, this doesn't apply but to this conversation, but there is some interest on the part of the towns who are negotiating with the tribe in southeastern Mass about where and how they're going to get money, because there's no ready mechanism for that besides the host community. So that's something we may need to talk about in another environment. How does take an example of Brimfield. Brimfield negotiated with a developer for a period of time, and eventually that broke down and they went away. The developer went away. Do we have a mechanism, or is there a mandate in the law, in the enabling legislation, for the Brimfields of the world, communities that negotiate for a while but don't end up being a host community or a surrounding community as part of an application? Is there a mechanism for them to get compensated for their expenses?
There's no mechanism for them in these regulations. There's no mechanism specifically in the statute for them. The host communities and the surrounding communities are the only entities that, under the statute, are entitled to seats at the table and compensation. That doesn't mean that we can't consider doing something, but it's not done here and it's not in the statute.
Can I clarify or ask a question relative to that? To the extent that the developer negotiating with Brimfield, to follow your example, were to be an applicant, there's a mechanism in these regulations. It's in the absence of being an applicant that
Yes.
Commissioner McHugh is responding.
Yes.
Is that, do you see the
You mean
distinction?
because we could say to
Yes.
that even though you're not Brimfield is not a host or a surrounding community, we want you, before we'll approve you, we want you to pay
Well,
Brimfield?
the trigger is when somebody becomes an applicant by virtue of depositing the 400,000 application fee.
Right.
If that never happens, there's no mechanism, if that's your
Oh.
example.
Well, let's,
Is that, am I?
the postulate, the chairman's postulate was that the developer has walked away from the town. So the developer is not going to become an applicant, at least for that town.
That's right.
And not for that town.
Right.
They may become an applicant for some other town.
Well, it seems to me, then we could think about that, but Brimfield is not a host, will not be a host or surrounding community for that application.
Right.
And so we would have to think about our power to deal with Brimfield after that walkaway applicant became an applicant for someplace else. There's no immediately visible path for compensation for the Brimfields of the world under those circumstances.
Right.
Doesn't mean we can't think about it, but it's not in the regs, it's not obvious from the statute,
Yeah.
and we'd have to think about it.
Okay. I guess, I mean, if our,
Yep, that's it.
our
That's a trigger.
ombudsman, or we ourselves, or our ombudsman could simply say to a Brimfield, if anybody comes to your door to start talking, first thing, you better tell them that you need some money to pay for your side of the table. That's, you know, that's all we can do at this point. We just give advice. Yeah, okay. Okay, so that's a little bit of a hole here that we need to think about. Not in this, but just the
In the
situation
world.
in the world, yeah.
Right.
Which chapter is this? There's one other phrase that I wanted to ask.
The fees chapter is one,
11403.
On page,
On page 61.
60, yeah.
61. I actually had a related question on fees that you might as well. In the two scenarios that Commissioner McHugh describes and are laid out in the regulations, if it's the route of money is deposited on the commission can then make payments to the host community and assess additional payments if that's the case.
and surrounding communities.
And, right, not just on host, but surrounding communities. Is there a test of reasonableness that is now de facto imposed on the commission? Because compared to the other, for the fees, reasonableness for the fees, compared to the alternative where the reasonableness hinges on what the community and the applicant would negotiate and agree on. The question is, does the commission, by virtue of following this alternative, because that may be one alternative, is obligated to test for reasonableness of fees?
well, the language permits the commission to disperse monies from the applicant's deposit upon receipt of a signed dispersal agreement, a dispersal agreement signed by both the developer and the town. So the negotiation is built into that process. There is not a reasonableness standard superimposed on that. In other words, the commission does not exercise independent judgment after it receives that dispersal agreement. I think I'm right on that.
Yeah,
That's
you
correct.
are, you are.
That's correct.
We also, I might add, Commissioner Zuniga, that, you know, part of that is to avoid interference in the local process in terms of their ability to negotiate with the developer. One of the targets that we were trying to hit here was to assure that there's adequate disclosure and transparency in the relationship between the developer and the town to avoid any corruptive influences or anything that, you know, might be done or frankly perceived as even being done. So the purpose of the disclosure was carefully drawn in that regard.
What if there's a dispute, which seems fairly plausible? How does this?
A dispute between the community and the
Right, in other
developer?
words, they don't get a letter of authorization.
But there would be no, under these regulations, beyond the $50,000, there would be no authority on the part of the commission to disperse money without the letter of authorization.
So we can disperse the 50,000 without the letter of authorization?
Let's see, No,
Whereas the applicant host community, the commission may at any time make community disbursements to the host from available amounts paid by the applicant to the community.
Right.
So there's the initial $50,000 under 031, which is now 14.031. And then there is the additional monies, if it says the last applicant, if the sentence that I'm reading from says, if the total amount of payments authorized by an applicant exceeds the initial $50,000, the applicant shall immediately pay to the commission all such additional amounts. So it covers both, actually. You need the agreement for both the initial $50,000 and the excess beyond the $50,000.
Okay.
Otherwise, we would be subject to, unilateral submissions, for example, without being able to be assured that this is the particular group that the town wishes to move forward with, and that particular
Yeah.
developer has
I
agreed to do so.
understand that, but what if they don't agree? What if the town says it's X and the developer says it's Y, and they don't agree?
And they don't get the letter of authorization submitted, and they don't get reimbursement.
So the town could, so we can't intercede, we can't, in other words, if the developer just says, I don't agree, I don't, that's way too much, I'm not.
That's too much money, yeah.
Then they stiff the town just because they don't agree to the town's amount?
Well, I mean, you're taking the town side there. But the answer is yes. They either, under these regulations as presently drafted, they either agree or the money doesn't get dispersed.
Right, and I'm following up on Commissioner Zuniga's point,
Would we be in a position
seems-
to test for reasons?
It seems like there would be perfectly appropriate, and, I mean, it seems very likely to me that there would be a debate about what the costs were. And it seemed to me like a good suggestion might be to have the commission, in the absence of an agreement, be able to make the judgment.
I think part of our thinking was, as a practical matter, and our experience is that the developer would not want to get on the wrong side of the town. And especially with the political process, the election process that's built into the legislation. So that it would be less likely, given those practical circumstances, that a developer would stonewall the community and refuse to pay for legitimate
Right, because
costs of
the community, the surrounding community, obviously the host community, they're gonna have to agree, but the surrounding communities have to submit a letter to the commission with the eventual proposal, right? So, as a practical matter, they're not gonna sign that letter if they haven't gotten what they think is fair compensation for their costs, so.
That's correct.
There also is another, and frankly, this is not explicit, but there's another break. And that is that if the $50,000 is exhausted by payments that are authorized, it's the commission's responsibility to issue a notice of deficiency and to get more money. The commission, I suppose, there's no specific provision in here for this. The commission could, if asked to dun the developer for additional sums, and if the developer responds by saying we're being asked for unreasonable amounts and we shouldn't be required to deposit some more, the commission could decline to issue a bill for more money. Now, that's not in there, and we can make, if we want to inject ourselves into the middle of this, we could add a provision dealing with this subject, but it was the thinking of the consultants, thinking of the team, really, that the best at this stage, at least, the best approach at this stage, at the phase one stage, where we don't have a specific proposal and we don't have a specific site-specific issues against which to measure the reasonableness of fees, that the best thing to do was let the developer and the town, city and town, agree, recognizing that in the phase two proceedings, where we will have a site-specific proposals, and recognizing that we'll have an opportunity for hearings, we could build in something that would be, give the commission more discretion in terms of making assessments for city and town compensation, even if that meant city and town reimbursement for monies that they spent somewhere along the way. It's very difficult to find something that's objectively reasonable when you don't have before you a proposal against which you can measure the reasonableness of the request for expenses. I think collectively we felt the commission would be basically shooting in the dark if it attempted to inject at the phase one stage itself into the negotiation process between the developer
Right.
and the town.
Okay. I'll leave this to the real lawyers in the room, but I gather that section 1 doesn't stand by itself, that it sort of looks that 031.
114.031.
Yeah, it looks like that authorizes the use of 50,000 at the commission's discretion, and then the next says with authorization. I don't.
That's right.
Yeah, they would be read together.
So they can't
that-
be read separately.
Yes.
Okay. Other things on fees before, or?
I actually, yeah, I had a couple. Just to reiterate, on page 62, section 114.03, subsection 3, the way it reads, it would appear that there's only one opportunity to do additional fees, or is this a continuum ability to assess additional fees?
Mr. Chairman, Steve Anderson, the opportunity is there both for the community reimbursement money and for the costs of the commission to assess additional fees as needed on an
Multiple
ongoing
times.
basis.
Multiple
Yes.
times. Thank you.
On page 63, section 4, I don't think that clause makes sense. I can't
Yeah,
read it.
I
Same
underline
thing,
that
okay.
too.
All right, so there's something wrong in section 4, it just doesn't scan.
There's a shall be assessed by the commission, that's too many, that we should strike.
Okay.
Where it
It's
says
a paragraph,
to an
Commissioner.
applicant, we should strike shall be assessed by the commission.
I wasn't quite sure what you were trying to get at, but it needs to be
All
rewritten.
right, so let's
One way-
rework
Yeah,
it.
let's just
Okay.
point out issues, and it just needs to be rewritten, unless we're misunderstanding, I think that needs to be.
No, I think I see
Okay.
the problem.
Okay.
Other, anything else on fees, or then if you're through highlighting things, Commissioner,
Yes.
then we'll just go ahead to.
Right.
You want to just go around the room? Commissioner Stebbins, do you want to start?
Thank you, Mr. Chairman. You know, some of the, I guess, the biggest area of interest that I had initially looking was more in the review or the application process. Information that we are requesting. Obviously, we've seen a new model of development, whereas a non-gaming developer steps forward in the lead position with a gaming operator partner behind them. They form a separate LLC. I was wondering if you can just walk me through where we were going to make allowances to capture those, what I would call kind of the new style of
Sure.
doing things.
Well, what we provide for in, would be 112, and 111 and 112.
Pages.
Oh, well, pages, okay. 111 starts at page 43, and then you would go on from there. So it's basically that section, 111, 112 is obligations to cooperate with what is required under 111. But what the applications seek to capture is essentially, as a concept, anyone with any influence or control over the operation of the applicant. And that would include the applicant's structure itself. So if you had a joint venture that was applying as the applicant, it would be all members of that joint venture, Corporation A and Corporation B, or Partner A and Limited Partner B. Both would be what are called qualifiers, which means they are the parties whose qualifications are a necessary precondition to the qualification of the applicant. They would be required to file application forms. That application form then in turn asks for all parties that have any influence or control over those applicants. And then that would be any owners of any corporate owners or individual owners of those entities. And then you go up the ladder or down the rabbit hole, whichever way you want to look at it, and you would be capturing the intermediary or holding companies as far up as until you get to the ultimate owner of the applicant itself. So it's a pyramid. And with each one of those entities, you would have each board member, officer, director, and shareholder of those companies with certain limitations. As the further up the pyramid you go, the more discretion the commission would have to be able to waive or identify those individuals within those entities that are really not as important as some of the other individuals. And so you have waiver provisions in these regulations that the commission would use to determine what is used in, called in the industry, scope of licensing, identifying which persons and entities are the qualifiers, and all of those qualifiers will be part of the application. So if you have, in your hypothetical, if you have a non-gaming, traditional non-gaming company partnering with the gaming company, both the traditional and the non-traditional would be scrutinized in the same fashion.
Okay. I had some other questions with respect to confidentiality, but I'm sorry to say I turned to our own attorney and abstention for some of that information.
You're going to keep it confidential?
Well, thank you.
Commissioner?
Yeah, I had a question, page 42, timing of the RFA 1 and RFA 2 process.
Section, please.
205, 110, 110.
We talk about.
Page 42, Commissioner?
Correct. Page 42, and I'm looking at 110.02, and bullet 2, we talk about the Category 2 license shall proceed. I guess that leaves it very vague, and we need to have further discussions about the timing of those two applications, correct? That's an internal
that's correct.
discussion that we have to figure out. Okay. I think I had a question about the multi-jurisdictional personnel disclosure form, but I think it was answered already by additional supplementary Massachusetts information that would be captured.
Yes.
And my last question had to do with, and I'm looking on page 65, which is section 150.05, determination by the commission. And having served on another commission where conditions and restrictions were involved, with a positive determination that could include conditions and restrictions, but the way I'm reading this is they would still be applicable to move on to the next phase, even though there was a condition and a restriction.
That's correct.
But at some point, that condition and restriction would have to be.
You have to be satisfied.
It depends on the nature of the condition. Some conditions are ongoing. There may be a condition for periodic reporting requirements. The commission will continue.
So you would talk about then a license with a condition is what
Yes.
you would be referring to.
Or in this case, a suitability finding with a condition, for example, but you would not be able to proceed in some cases unless you met the condition. For example, the company, the applicant is fine except for one individual with whom you have a problem. The condition would be if that individual is removed from the process, they could move forward. So they would not be able to move forward unless they met that condition.
Okay. Thank you.
So just to pick up on that, 11505 number 4, you'd issue a positive suitability determination on that applicant with conditions and restrictions removed. I mean, do we need to make it that specific? As you're talking about that in 3.
Right.
It says shall not entertain a phase 2 application for an applicant unless commission has issued a positive suitability determination on that applicant. Do we need to make it clear that previous conditions have been met or
Well,
satisfied?
again, it depends on the nature of the condition. There will be certain conditions that will have to be satisfied within a certain time period, but there will be others that could be ongoing, that do not necessarily have to be satisfied, because there will be a determination of suitability.
So that would be articulated in a determination letter as opposed to the regulation?
That's
That would be
correct.
the more appropriate, okay.
That's
It's
correct.
very
That
common
makes
in
sense.
the industry to have statements of conditions
Yes.
attached to the
Yes,
determinations.
there are standard conditions that do not impact on an ultimate determination of suitability that are generally imposed by a regulatory agency.
And that, one of our guiding concepts here was to try to find a middle ground between the regulations being so specific that it hamstrings you in what you can and cannot do, but at the same time, specific enough so that it gives guidance to the applicants and guidance to the commission. And that would be one of those areas where you'd want to have some flexibility as to what the conditions are and how they're articulated.
And I just wanted to point out one other thing, Commissioner, in response to the RFA, Phase 1 request for applications. The particular materials, when you do the order, statutory required order of the RFA 2 first, the application materials and the standards of it are the same, okay, in
Yes.
terms of what will be issued. So the same material is going to be required of the applicants, regardless of the particular place. So the same depth of investigation will be conducted.
Okay, thank you.
On that same section, apparently, I wasn't aware of this, so I guess I just didn't understand this. So when the Bureau makes a decision on suitability, gives that recommendation to us, and then ipso facto, there's an adjudicatory hearing on it. We don't just announce it, and they can appeal if they want to. We have to have, what is that? What does it mean in this context to have an adjudicatory hearing?
Means that we're going to have a formal hearing where people can present testimony, where if we have questions about issues, we can highlight the issues, take testimony, and hear evidence in the normal sense of the word, hear arguments, take all submissions, and then retire to deliberate among ourselves as to what the decision ought to be.
So it's essentially giving them a formal opportunity
That's right.
to contest or question, okay.
Or present their case.
Their case, right.
That'll be the one opportunity that an applicant will have to present its case.
Right.
Because there is no hearing in front of the Bureau for a
Right.
gaming license.
But if the Bureau recommends that we accept an applicant, there's still an adjudicatory hearing.
still
You
an
may
adjudicatory
disagree with
hearing.
that recommendation.
Okay, all right,
Right.
okay. Commissioner, did you have a?
No, that.
Okay.
Complete.
Just in no particular order, other than pages. On page 44, we have this business entity, this happens, we have the business entity disclosure form, which is that standard form that you had given us earlier, I guess. This was for New Jersey, right? Right. But then we go on for pages and list all the information that we want. Isn't that all in this form? Why do we list all this stuff when all we need to do is say, we're gonna give them this form?
It's,
Or is there stuff, is this?
Which was part of what we were talking about before. In order to, there's one repository where people can go and say, well, if I want to file a form, what do I have to file? They can read the regulation and see what's in it. They also could go to get a copy of the form off the commission's website. But it's fairly traditional in gaming jurisdictions for the regulations to list the elements of the application form in the regulations.
But it's basically listing what's in here?
Yes, it is.
Okay, all right. One of the suggestions that was made at a brainstorming session that we had with people about the affirmative action and diversity criteria in the legislation, which we've all talked about a lot and want to take very seriously, was that there might be something that we could do at this stage of the process to, at a minimum, give a signal that this is something that we take very seriously, and maybe learn some substantive stuff that would have something to do with suitability. I'm not sure about that. But would it be, and I'm asking everybody this, would it be appropriate to add in something here? I mean, a simple example would be to identify the gender, race, ethnicity of your senior management and board of directors, for example, as wherever that fits in this structure. That's something I'm going to be interested in knowing when the time comes. So is that something, and one of the things that would, first of all, that tells us something interesting, assuming that it's legal for us to ask the question. Secondly, it gives people a heads up that this is something that we take seriously.
There wouldn't be no problem in adding that to the application form. The issues arise, as you've pointed out, legally with what you could do with that information.
Yeah.
Whether or not it could become a criteria for a license is questionable under recent court decisions.
Right.
But the availability of the information certainly is something you could get either in the application form or during the course of the application itself. You're empowered to ask every applicant for anything that you want.
Yeah. Well, I haven't thought this through at great length. It was a suggestion that was made that I thought was a really interesting suggestion, and I was going to talk about it in another context anyway, but I throw it out there as something that seems to me, it seems to me it's a pretty, you'd have to figure out how to do it and where to do it, you know, but it seems to me it's making an important point that we mean to be making. And I'd suggest that we add that, but I'm game to hear other people's reactions.
I think I talked about this with Guy at one point, you know, using this RFA1 process to get an idea of how any of these entities conduct themselves with in the area of reaching out. How do they contract with small business?
Right.
Another priority within the legislation. And, you know, the suggestion was made, well, if you incorporate it in the regs, it sends a signal, sends the message that it's important. The flip side in thinking of that, instead of overburdening the document with more information, at least going through this RFA1 process, now we identify who the players are. They're filling out the paperwork, they're stepping up, writing out the check. Can we then use that as an opportunity to have that follow-up conversation with them to say, we'd be interested in whatever your hiring policies are, the makeup of your board, what are your standards for contracting out to small businesses, and use that separately, but know that who we're talking to is pretty much step forward and identify themselves. So I saw it as getting to the same end goal, but maybe not necessarily incorporating in the regulations. But if as a commission we ask for that type of information, so we can begin again to work with them and think about how the state or how this commission needs to react and position itself on those issues. Just requesting it because we know they're going to be a player down the line might be a way of us achieving the goal that you're interested in, and I am interested in, as opposed to folding it all into the regulations. But
I think it's more powerful to fold it in this topic as well. I meant to mention both things, because you brought this up before. I think it's more powerful to figure out a neat, strategic, not onerous, but smart, neat way to do it within the context of the regs. That makes the strongest statement on both points.
And who is it that you'd like to, and I hear you, because if you look at page 45, it seems to me that we could, if we wanted to, add to 8 and 9 at the top of the page, assuming our pagination is similar, where we ask for the name, home address, business address, yada, 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 of current and former directors, trustees. We could add questions about ethnicity. It's easy to slip that in.
And gender, yeah.
And gender.
Yeah.
And for 9, for the officers, and for the former officers.
I think, I'm not sure exactly where each place it would go. I'm not familiar with enough to know whether that does the trick. But if it does, I think what's really interesting and telltale is the nature of the senior-most leadership. That's where the rubber hits the road. That's where the issues are. That's where the challenges are. So whatever that is, if that covers it, if 8 and 9 covers it, then fine. But
That would be the directors and the senior manager.
Senior manager.
Right.
But it's different for different kind, well, I guess you covered it all, yeah, trustees, partners, does the language cover all the different corporate structures?
It does.
Okay, yeah.
If that's your direction, we can certainly add that in.
Yeah, well, but is that a consensus that everybody's okay with? How about, where is, sorry?
So we capture the information, but we can't necessarily use it, correct?
You can't use, well, it's an issue.
Tricky.
It's an issue.
Very
It's,
tricky.
I guess the recent cases talk about having to establish that there is pre-existing racial discrimination or sexual discrimination in that particular industry. And the problem with the gaming industry is that since it's new, there's no real ability to go back and make that demonstration. But there can be uses in terms of established goals, or but just whether when you get closer to it being a criteria for the license itself, it gets trickier.
So we certainly can capture it. I think that an offshoot of that is, and this is law that's in flux now. We have a major Supreme Court case next term that's going to take another look at all of this, and the benefit of asking this question is that we get the answer. What we can do with it is yet to be determined. Downside of asking the question and getting the answer is a claim that you improperly used it when you made the final decision. And basically then having to disprove that we misused the information. I mean, so this is nothing in this environment is risk-free. But the impulse is one with which I agree. There is a need for diversity in our society, in our life, in our country. But these are the issues we have to think about.
Well, I mean, I think we're a long way from getting sued by misusing the data. So I would say if that we ought to go ahead.
Well, nobody's going to sue us tomorrow. This lawsuit won't come until we make the license.
Well, it's not right. That's right. But it's, yeah, to grant that's a possibility. But and what about is there a similarly interesting? We could ask people to sort of append their local hiring.
Well, it got to a question more of, and again, I had this thinking out loud. I was like, this is information we want to collect. The statute talks about a gaming operation having an impact on small business, and we've deemed some information. We've gotten some information about spending categories. I didn't necessarily, I like you, with respect to equal employment opportunity, I think it's a priority, and where we state it may raise the level of awareness to it. I didn't really find a particular place where it fit in neatly to say, tell us what your spending categories are, when obviously this RFA1 application is more in detail about who you are and who the folks are that make up your company.
Well, if you're comfortable.
But I'm happy to,
if you're comfortable,
follow it up
yeah.
after we know who the applicants are, to say, we want to begin to work with you on, supporting small businesses. Show us we invite you to share with us your spending categories. And hopefully we'll gain a level of cooperation. I see us getting the same effect by either having it in the regs or as a commission sending out a communication that asks for that information.
While I would wholeheartedly agree that it's a critical matter to take up, I think it may best be a part of the Phase 2 regulations that'll be drafted, as opposed to suitability determinations.
Sure.
Yeah, I would agree with that, also with the need for diversity, but at the same time, the issues that we're raising may be more acute when, remember, we're asking for that information in terms of the only decision we're making here is suitability on background. And if we're asking for that information in the context of suitability for background as opposed to your overall suitability for your ability to have a successful project, it may be more questionable than if we ask it later on.
Yeah, there's certain information that while the commission may be well within its rights as an agency to require an applicant to provide, there are limitations as to what can be provided in an application form based on case law.
Okay.
We have to be concerned with.
Okay. All right. I'm happy to look at that process separate from the RFA1 process.
Okay.
That's fine.
Yeah, I was on the same camp of thinking about these more towards the RFA
Of
phase
his
2.
issues.
No, asking these questions
Are you
towards
talking about
phase
the
two.
gender, risk, and ethnicity as well?
Gender, race, ethnicity.
Okay, I thought you were just talking about the second one, because I would much rather put it in the regs now. I mean, people are gonna hear this conversation, the word's gonna start getting out, that these are important issues. But I think I just think it makes a statement that is an important statement. There's no, like, the downside risk of being sued as a consequence of it,
It's very small, in your
I would
opinion?
think is tremendously small, you know.
Well, I disagree with that, but, and not an overt lawsuit, but at the end, I'm not saying we shouldn't do it, but I don't think we should minimize the potential for litigation arising out of acquisition of any information that we, in somebody's view, are not entitled to have. This is an area that's in flux, and so I think we ought to make a judgment about whether or not we want the information, but I don't think we ought to diminish the risk, not of somebody suing us for money, but for somebody saying we made an improper decision because we took into account information we weren't entitled to have. That's where the rubber's gonna meet the road. I think it's worthwhile, because we do feel strongly about that, I think, at least I feel strongly about the desirability of diversity, putting it in this draft regulations, putting it out for public comment. Let us see what the reaction to that is, and let us make a judgment as we measure the comments. We'll have another opportunity to do it, that's what this is for, and we send a signal to the world in the process that we're interested in this topic. So I think it's worthwhile doing that.
Great, yeah, there are other bites at the apple, that's a good point.
Chairman, can I just bring your attention to one other section? In section 15, which is the criteria.
What page is this?
This is for the
So
statute.
this is on the statute,
Oh,
okay?
okay.
In section 15 of the statute, it sets forth the criteria that an applicant has to meet before a license can be issued. One of those subsections in section 15, subsection 16, the applicant's required to formulate for the commission approval and abide by an affirmative action program of equal opportunity whereby the applicant establishes specific goals in the utilization of minorities, women, and veterans on construction jobs, provided and so forth. So there is some recognition in the statute of those goals and objectives.
Oh, I understand that, and that, we make that, it also has to do with use of minority vendors, minority and women vendors. So we're not saying we're creating this out of whole cloth. We're taking a message which is clear. We're taking a value which is established in the legislation and making it stick.
Now, the target in looking at these statutory requirements was that this was going to be incorporated in the phase 2 regulations, but if the commission feels otherwise and prefers that we draft it in terms of the phase 1, obviously that can be done. But to emphasize the point that Guy made, it's got to be quite clear that it does not impact on the finding of suitability, or you will be exposed to litigation. It can be a determining factor in terms of awarding the license in a competitive bidding process. That's a different.
Right. Right. So I think we're agreed to go ahead and put it in, see what happens, see what kind of feedback we get, and make a final determination at the end of the day, at the end of the process.
I have a number of little
Okay,
questions.
yeah,
and
I'm
but
just going
I
through
see
mine.
that you too, so
Yeah,
we
so,
can.
well, let me just go ahead if you want to, or I was just gonna keep going through mine and get to yours, go ahead.
Well, what section were you in last?
I'm
maybe
just
we
going
can
through
go
page by
section.
page, I'm now at page 57, withdrawal of application.
Go ahead.
We talked before about
Which
this.
page?
57. This is the withdrawal of application, and I don't know whether this is worth talking about or not, but when we're talking about reasons for which we might not allow withdrawal, and one which might seem to me that might be worth mentioning is some unpaid financial obligation. You know, if you've negotiated with a city or town, for example, and you owe some money, or you owe the commission some money, you can't withdraw until that money is paid. I don't know if it's worth adding that.
There is, in the subparagraph 3, 1105.3, it says, if the commission agrees to grant withdrawal under any of the circumstances, and 2, the commission may condition that withdrawal with appropriate terms it deems necessary, including but not limited to a period of time within which the applicant may not
I
comply.
agree, it's not worth worrying about. So, but my bigger question sort of goes to the conversation we had about this before. How do we enforce non-withdrawal? What does it mean to not let somebody withdraw?
The commission would go ahead and deny the application. Frequently, what will happen is an applicant which is confronted with a negative suitability report will seek to withdraw because there are ramifications in other jurisdictions for a denial. So the regulatory agency may decide, based on that negative information, that it does not wish to allow the applicant to withdraw its application and go forward with its finding of a negative suitability.
That impacts that applicant in other jurisdictions.
We won't rehash that, okay, I
It's
get
a
it.
It's a
puts you
relatively
at,
common matter.
yeah, and if it puts you at ease at all, it happens in litigation all the time.
Mhm.
You don't have a unilateral right to withdraw your lawsuit.
Right.
So,
Okay,
so,
I'm fine. On page 61, we talked about that, sorry, that was the issue we talked about. A big question, on page 72, we enumerate some sort of standards. The question, make sure you have enough money to pay your bills, make sure you're capable of refinancing, things like that. But as a practical matter, are we essentially left to make ad hoc judgments on our own using whatever criteria? I mean, you might have debt to equity ratios. You might have operating cash flow. You might have any of a host of a million things that are metrics that say this makes you financially suitable. The way this is written now, whether financially suitable, character suitable, too many marriages suitable, whatever, we pretty much can make the decision based on whatever standards we want. Am I understanding that right? And is that what we want to do?
That's a policy judgment on your part. Obviously, from our perspective, again, we tried to balance the need for discretion with the need for guidance. If we felt that if the standards, either on character or on financial stability or any of the licensing criteria, were too specific, they might not capture everyone you might want to qualify or disqualify. Then this gives you that discretion to be able to make those judgments on a ad hoc, as you say, but case by case basis.
And is there any problem with us having that kind of discretion?
No, it's commonplace throughout this industry. It's a very broad discretion that's given to these gaming agencies.
Just out of curiosity, I mean, what is the I know the law says that we have the final decision and there's no right of appeal, but you can appeal, right? You can.
Yeah, I don't want to go on record saying that the legislature didn't say, but I would assume some enterprising creative attorney would figure out something, I would think, right? But is there, I'm just.
What's
remember,
troubling you?
there could be conditional approvals. If there's a debt to equity ratio that it may be a little too close to comfort, that could be explored, and the applicant may be able to later on fix that.
Right.
But we won't really.
Yeah.
No,
I like it this way. I'm just wanting to make sure that.
You're troubled by the absence of any firm standards?
I'm not troubled by it. I like it gives tremendous discretion for us to exercise our judgment, such as it is.
Right.
And I like that. And I think that's why we were appointed, and I'm happy to do that. But I'm questioning whether that is the best policy, and wondering out loud whether that's appropriate and that much discretion.
From my standpoint, the discretion, the statute is constructed to give us that kind of discretion. And these regulations are designed to illuminate the qualities that we're going to take into account and exercise that discretion. And then it's incumbent on us to make a reasoned, explainable decision as to what we've done, so that we do not give the appearance of or actually simply vote with our gut, that we have a clear, articulable basis for the decision-making that we do. And in that way, we constrain our discretion in a sensible way. And I think that combination is the ideal way to proceed.
Plus, remember, there is this phase one at this point. There's only a determination of pass with conditions, or fail. There's no grading at this point yet.
Right. Okay, good.
Hey, just to follow up all around this section, I mean, it's the criteria, the ability to maintain, the ability to meet, that sounds a little prospective about their project, but I'm assuming what we're doing is we're looking at, has a history demonstrating its ability to maintain a gaming establishment.
That's correct. That's correct. And even further, these regulations have been drafted specifically as phase one regulations. There will be potentially, there will be modifications to these regulations when it comes to phase two, because the financial stability evaluation has to be made in the context of what it is that you're intending to build. What will your operation look like, and can you afford that operation? We don't know that in phase one. So what we've drafted here is just a standard of typicality. What typical, do you have enough money to run ordinary typical casino?
Okay, so you would see using this same language in the RF2 piece, almost verbatim, because again, I'm thinking of ability as prospective as opposed to, we're still looking at your financial suitability and your history.
Essentially, yes, but they would be, these would be, the evaluation would be geared to a specific project in phase two, as opposed to esoteric kind of possibility.
On page 72, down at the bottom, section 3, I don't understand exactly what that means, just out of curiosity.
Well, that was what we were saying, what the point I was trying to make, that this finding of financial stability is not binding on the phase two evaluation of financial stability. The financial stability you're demonstrating now is just in general terms. The phase two demonstration would have to be in specific terms regarding your project.
I see. I got it.
Context.
Right, got it. Okay, got it. I'm not sure these are worth talking about, but on page 70 at the top, these are things where we want to waive qualifications, waive qualification requirements. And one of the things you mentioned specifically is persons involved in the financing of the gaming establishment. Why would you, seems like that would be one of the most important categories of people that you would want to, I mean, what this does is give us the right to waive anybody we want to waive, which is fine. We can just leave it at that. But I just was curious why you would single out.
It's intended primarily for banks and other licensed lending institutions. There needs to be a mechanism to enable those entities to participate in the gaming industry. They become a major factor in providing financing.
Given what's going on with the banks in the world, I think it might very well
That's
be.
another
Okay,
story.
okay.
Well, you don't have to
Less
waive
waivers.
them if you don't want to.
Yeah,
That's right. It's, this waiver is
Yeah.
always a discretionary
Okay.
matter.
that's fine.
Definition
Good.
of persons that I think.
Yeah. On page 69, we talk about, in the application, if the applicant is a limited partnership, we want the background information on each close associate. Is that a
It's a
legal
term
term?
from the statute. That's what the.
Oh, from our statute?
Right.
Oh, all right. I'll pretend I didn't ask that question.
And it's a very broad definition.
Yeah, right. I thought maybe that was a term of law that I was not familiar with. Okay, I think,
I have a question from that section, if I may.
Sure.
Since we're there.
Yeah.
11602, persons required to be qualified. And there's a very broad, on subsection 3, in the judgment of the commission, in accordance with chapter 23K, a number of individuals, including each employee. And I was just wondering, when is it anticipated that the commission will make those judgments, or is this the Bureau? And what is the Bureau's role in determining this sort of scope of license, or this qualifier, determination of qualified individuals?
The way this usually works is that an applicant will appear, we'll just schedule a conference with staff, the Bureau, and present their structure, their table of organization, and all the ladders all the way up. And then determinations will be made as to who in that structure, in that picture, will require to be qualified. It's not as simple as sitting down with a piece of paper. You really have to see the background information, and if there are, lenders, indentures, and what authority they have, and, what is the debt convertible to equity, and all of those issues that determine whether anyone in the ground rule is whether anybody has influence and control over the operation. And then at that point, the Bureau staff will make a determination, and ultimately the commission, if there are still disputes over who needs to be qualified, then the commission will make a determination and a final finding as to who the qualifiers are.
It is a frequently very arduous, time-consuming process.
Yeah.
Based on our prior experience.
Right. Well, if it's each lender, for example, which was a prior conversation, that could be very, very lengthy.
Right. It is.
Even if it's no to this and no to that one.
That's right.
It could be very.
The only other questions that I have to do with these two forms, and to me, there's a lot of stuff in here which is inexplicable. I mean, asking people whether they have scars or tattoos, asking people how many cars they own, how many times they've been married. I mean, there's dozens of things in here that seem to me to be, on the face of it at least, of very marginal value. And I wonder whether this document has just sort of grown like Topsy, and has anybody ever gone back and edited this thing to see whether it really makes any sense?
They've been edited. You would be amazed at what the original business disclosure form looked like. Fortunately, I was tasked with having to modify it. That was not a very pleasant exercise in New Jersey.
Well, why would we want to know how many cars people own? For example?
That gets to financial, yeah, and
Gets to
the
what?
real.
Financial.
That is an element of financial stability.
Well,
there are many facets of an applicant's financial stability.
Yeah, not only their stability, but their integrity. The source of fund analysis and investigation is key to all of this. So if you declare in your financial statement that you have $20 in the bank and you've got 3 Mercedes, that's questionable. And where'd you get the money for the Mercedes?
But we're talking here about the major players in these major organizations, right? We're not talking
But
about.
this form applies to everybody. This multi-jurisdiction form is filed by all of not only the owners and the directors, but all employees too, key employees. And so it's not just for the highest level.
And also, when you say major players, they are not immune from providing false information.
Well, I understand that, but that's
Right.
not.
So, I mean, these forms have been historically set forth to deal with the various matters that come up in an application and an investigation. And they were streamlined sufficiently over the years to eliminate many of the concerns that regulators and applicants had, that there was too much of an intrusion. And there was what was considered by most regulatory agencies as a fair balance for the information that is requested. Now, is it more intrusive than what other administrative agencies ask for? Yes, because the nature of the casino gaming industry has always been that.
that this is a very intrusive examination of an individual or an entity's background, all
Well,
facets.
I understand that that's appropriate, and I want us to be as rigorous as we can possibly be, but I'd also like us to be smart and not stupid. And it just, I get my back up at this stuff. I mean, I just think this, and maybe I'm wrong here, and I'm happy to shut up if everybody agrees with me, but you know, to track all the cars that your dependent children own, even though they might be 50 years old and live in another country, I mean, it just doesn't make any sense to me. It seems like we're putting people, I mean, it feels to me, and I haven't really thought about this a lot, and that's why I'm bringing it up now, but it feels to me like we're putting people through some pretty rigorous hoops that if you're a bad guy, this is not going to solve the problem. You know, he's not going to tell you the fact that he's got, you know, a bunch of money in Bahamas that's illegal on your disclosure form.
But
You're
you
going to
may
figure
be able
that
to-
another way.
You may be able to find that through that information. For example, a former spouse is always a good source of information, which is why we require that information. Tattoos and scars, also another identifier which can lead to something else that may not be disclosed any other way. So I actually think those are legitimate
well-
questions, and it is meant to be, intrusive
Yeah.
for good reason.
Yeah, don't get me wrong, I'm in favor of being intrusive where it is smart and appropriate for us to make sure we're getting good people. I'm totally with that. And if somebody doesn't, if we have to ask questions that are hard questions and they don't like it, that's their problem. But I just want to make sure that we're being as smart about it and thoughtful about it, and not just reflexive, not just doing what everybody's been doing for the last 40 years, without thinking it through and thinking, does this really make sense? Does this really help us accomplish our public policy objective?
On the car issue, which appears to be troubling to you, was also troubling to me when I filled out applications for licenses before myself. I point out one thing, the way it was explained to me. The registration information that goes with that car will have with it addresses. And that addresses is useful in terms of property holdings and residences, multiple residences. Sometimes it's used also for driver's license in other states where that registration is tied to a driver's license that may or may not have been revealed. That driver's license may have on it a series of misconduct deeds that the particular applicant may want to have concealed and didn't disclose. There is a useful line to it. And the balance of those kind of things, gun ownership's another example in terms of the amount of information required. But that information in this type of in-depth investigation is cross-referenced to the rest of the information, like Commissioner Cameron pointed out, the scars and tattoos. That's cross-referenced to prior applications to make sure that the same person and so forth, and verifications with fingerprint cards that may have been filed 25 years ago if necessary. But all of that information does build on it. There is a rational basis for it. It sometimes not appears at first, but I know particularly in the cars, the registration and so forth, there is a value to it, if it helps you.
Well, that does help, and that's what I'm looking for, is, you know, is there a rational basis for this? And, you know, you're a professional in this business, and at least two of you are too, and if you don't have any doubts about this, you know, off the record, I mean, not really off the record, but just, if you're just guys who have been around this business for a long time, sitting, talking off, you know, casually to people, saying, is this the best we can do? Is this the best we can do? Is this, under the circumstances, appropriate, fitting, you know, not nonsense? If that's the way you feel about it, then and you too, then I'm fine with it. You know, I just want to make sure we've asked that question
And it's
hard.
a very fair question, and what the experience of agencies has been, and our experience collectively, is that if we are to err, it would be to err on the side of disclosure, because you never know what piece of information might be the piece of information that triggers other information that gets you to the result you want. We've, as Steve has explained, narrowed that concept down to this document at this point, and it has been reviewed fairly recently. And not that it's perfect, but it certainly has been useful, and we would recommend it.
Okay.
Not that an applicant is going to look at it as his favorite thing to do.
Yeah, well, I'm sure of that, right.
Your objection.
The only other observation I have on these is that there seems to me to be bouncing around on the terms, 10 years, 15 years, 20 years of look back, and I couldn't figure out a rational basis for which is what. I mean, the 10, 15, and 20 all appear in each of these documents, and maybe it doesn't make any difference, but it'd be nice to know if there was some